Ladies and gentlemen, dear colleagues and friends, it is my great pleasure and honor to welcome you to the 6th EFILA Annual Conference. My name is Nikos Lavranos, and I'm the Secretary General of EFILA. This is the 6th lecture in a series which was kicked off in 2015 by Sophie Nappert, followed by Johnny Feeder in 2016. In 2017, we had Judge Christopher Greenwood, and in 2018, we had Professor George Berman, and last year, we had Professor Laurence Bosson de Chazonnet. So without exaggeration, I think it is fair to say that this series of annual lectures is now an established event in Brussels and today online. This year, Professor Lucas Mistelis of Queen Mary University of London has kindly accepted our invitation to deliver the 6th annual lecture. But before introducing him and the other speakers, please allow me to say a few words about EFILA and its upcoming events and activities. EFILA was established about 6 years ago as an independent non-profit think tank, with the aim of providing a platform for fact and merit-based discussion on the EU's investment policy. Our members are lawyers, arbitrators, and academics who have extensive experience in investment law and arbitration. In the past 6 years, we have been organizing our annual lectures and annual conferences with increasing success. Indeed, the next annual conference will take place on 14 January 2021 online, and you can register already via our website. EFILA also regularly participates in the public consultations of the European Commission, the ICSID Secretariat, and other organizations. Moreover, EFILA has also been granted observer status in the UNCITRAL Working Group 3 on ISDS reforms, and we have been submitting our position papers to the working group. And if you are interested, all EFILA publications can be found on our website. In addition, Queen Mary University of London and EFILA also publish annually the European Investment Law and Arbitration Review, which is currently in print and will be published in December. This issue will be 480 pages thick and contains many very interesting and relevant articles. And it is good to know that you can order the review directly from the website of Brill Martinus Nijhoff Publisher, and you can also buy each article separately and electronically. In short, I think it is fair to say that EFILA has established itself as a think tank that provides a unique perspective in the debate on ISDS reforms and more generally on the EU's investment policy. But let me now very shortly introduce our speakers, who in fact do not need any introduction at all because they're all very well known to you. So, Professor Lucas Mistelis is the Clive M. Schmidhoff Professor of Transnational Commercial Law and Arbitration at Queen Mary University of London. He's a very distinguished expert in investment treaty arbitration as well as commercial arbitration. Indeed, he is recognized by his peers every year as an outstanding expert and thought leader. He has acted as arbitrator and counsel in numerous cases, and he is also the chair of the executive board of EFILA. Moreover, Professor Mistelis has published dozens of books and articles and has conducted numerous surveys regarding investment law and arbitration issues. And today, he will talk about the latest one. And this brings me to Tom Sikora, who is the chair of the Corporate Council International Arbitration Group, which supported the preparation of the 2020 International Arbitration Survey, Investor-State Dispute Settlement, which will be the topic of today. He is also Senior Vice Chair of the Institute for Transnational Arbitration, and He is Senior Counsel International Disputes at ExxonMobil Corporation, and thus brings a tremendous experience in arbitration disputes to the table. This can also be said of Mrs. Nienke Höpken-Zipma, who is the Director of Legal Affairs at Achmea, the insurance company that will always be associated with the EU's efforts to prohibit arbitration within the EU and to terminate the intra-EU bids. She's also member of the advisory board of EFILA. Then we have also Mr. Victor Orellana Martinelli, who is the upstream international negotiator attorney at Total, and who also has a wealth of experience in arbitration disputes, in particular in Latin America. So he offers a perspective outside the Brussels bubble, which I think is a very healthy reality check. Last, but certainly not least, we have Mrs. Laura Halonen, who is of counsel with Wagner Arbitration and has more than 10 years experience as counsel in investment treaty disputes. And moreover, she's also the chair of the advisory board of EFILA. And Laura will be moderating this event. We will proceed as follows. First, Professor Mistelis will deliver his annual lecture entitled Investors' Perceptions of ISDS, a Moral Philosophy Approach to ISDS. We will then allow for a first short round of questions regarding his lecture, which you can send us through the chat option during his lecture. After that, we will open the floor to the panelists for a first round of reactions. And in the meantime, we encourage you to pose your questions, which we will then feed into the discussion. At around 7, we will wrap up this webinar. So without further ado, I will give the floor to Professor Mistelis.
Thank you very much, Nikos. This is a very, very kind introduction, and one becomes very acutely aware of the excellent line of speakers that addressed the EFILA audience before me, and perhaps make my task slightly more demanding. What I would like to do is to effectively, as you indeed say, address the Queen Mary survey, the Queen Mary and Corporate Council International Arbitration Group survey. But I would like to give it a bit of a context. And the context I will give it is slightly philosophical and perhaps with some aspects of legal theory. So the topic is of course very close to my heart and my academic research. And I will address it as following. After a series of preliminary remarks and setting, if you wish, the scene, I will provide some discussion of several key data and address the survey from an angle of a moral philosophy context. What are these preliminary points I would like to make? First is a point of terminology. I will be using the fashionable term investor-state dispute settlement, ISDS for short, but I will also make the point that in my view, ISDS is a misnomer. Technically, ISDS encompasses or ought to encompass all methods of dispute settlement between foreign investors and states, ranging from dispute settlement between foreign investors and the states, and also amicable settlements, cooling off periods, the rarely used mediation and conciliation option, and investment treaty arbitration, the pure and delocalized one under ICSID or the hybrid one under ancestral ICC or SEC or other arbitration rules, and would even encompass domestic court proceedings. It would even encompass, if you wish, state-to-state arbitration and diplomatic protection. So ISDS or the ISDS that is being attacked, if one were to be blunt, or if one to be more diplomatic or politically correct, is under review, is actually investment arbitration. because the reformers of the ISDS process want to keep and even enhance investor-state mediation, and even perhaps encourage further recourse to domestic court litigation. However, the term is typically used in a shipping fashion. Think of a bulldozer in that sense. And I should mention at this stage that what is being proposed is to replace investment arbitration with a permanent multilateral investment court system. The second preliminary note I would like to make is that generally the topic is dealt with in an emotive fashion and with quite a bit of passion. And it's an area of where developments happen at a rather unprecedented pace and with a high degree of polarization. Opinions are sharply divided, and there are opponents and proponents of the two polar positions, proponents of the status quo and opponents of status quo with proposals for radical reforms. What is also very important is that a lot of the proposals come by newcomers, and you will notice that I use newcomers in inverted commas. In that sense, for example, the European Commission is rather a newcomer, is not a traditional stakeholder, because the EU is not a state and is not a respondent to disputes. The EU member states which have been active, either having other investors investing or having been recipient of investment claims, seem to have taken a backseat or at least have delegated their policy formulation to the EU. And in addition, of course, to regional economic integration organizations such as the EU, we have a number of non-governmental and intergovernmental organizations who have become significant policymakers in the area. As far as the EU is concerned, I should point out from the outset that a system that has served, and I use the word system reluctantly, a system that has served European investors, whether large, very large, but also small and medium-sized businesses over the years. And there's no doubt that European companies collectively have been by far the primary and more frequent user of ISDS, are gradually deprived, or will be deprived, of the right to recourse to investment arbitration, and the right to protect their rights arising under an investment before a neutral, depoliticized forum. Almost all repeat users come from Europe, with the US being the single largest state of prolific investors or claimants. But if you put all the European states collectively, Europe is a much larger user of the ISDS. Of course, such rights are conferred by international investment agreements or national investment laws, and agreements and laws are drafted by states, not by businesses. Businesses, when they contract with states or state-owned enterprises in sensitive business area, such as mining or energy, but also finance and infrastructure or construction, acknowledge that they assume a risk, and they often classify this risk internally as a rule of law or political risk. So they would invest being very much aware of that risk, and they will price the investment according to the level of risk. Governments come and go, laws change, and the stability and well-being of any sensitive investment is ultimately in the hands of state, central, or local administration, but even state national courts. As Heraclitus could put it, tapanda rei, everything flows, unless, of course, you have a stabilization clause or an FET clause in the BIT, which protects legitimate expectations. Then, and that's the final preliminary point, the topic is also dealt in a rather from an intellectual or ideological approach. To simplify that sort of that point, do we have confidence in privatization of business and also privatizations of the administration of justice? What is the stance one's take in relation to globalization? Or has resource nationalism, nationalistic populism of the Trump or Putin or even Brexit type taken over? To give you an example, in London, where I live as a Greek, I get my gas from Gazprom, my electricity from EDF, that is Électricité de France. My bank is a merger of a big Hong Kong bank with an English bank. My coffee is Italian or Guatemalan, if I have the choice. My watch is Swiss. My carpets are from Persia. The chandeliers are from Austria. by computers designed in California, but produced in China, and the list is very long. Any disruption of any of these services, which necessitate a globalized world, would have an impact detrimental to me in the way I live my life, or me and my family and my friends live our life, and may be the basis of a trade or investment claim. For example, if the UK government will interfere with EDF's or Gazprom's operation. But as I will address later, trade claims, international economic law claims, are different from investment claims, and a lot of the confusion arises from treating them the same way. So in the early 1990s and early 2000s, the fancy topic was the creation of non-state actors as policymakers and rule makers in international law, the role of multinational corporations and NGOs, and the reduction of the role of the state. If one is comfortable with privatization, she also ought to be comfortable with the privatization of the administration of justice, that is arbitration. And if one is comfortable with globalization, or at least internationalization, she also ought to be comfortable with international dispute resolution system, provided which provides offshore adjudication by adjudicators retained privately. There are many good reasons why one ought to use domestic litigation for certain disputes, or disputes specifically which require a state endorsement, for example, the validity of a patent. However, there are also many good reasons why one would wish to avoid domestic court litigation if there's a suspicion that domestic courts may be polemic or political or even corrupt or just inefficient. If one were to look how courts, even in EU countries, fare, might well have second thoughts before initiating, as a foreign investor, proceedings against a state in its national courts. For example, recently, there were Court of Justice of the European Union decisions about Polish courts. There were also discussion about other courts in the EU. The Financial Times last year, in a compelling piece about IPAC and Turkey, the difference between domestic and international rule of law, was advocating the importance of international rule of law, where domestic rule of law falls short of basic minimum rule of law standards. Still, in more recent years, the trend has been reversed, and the idea is to have the state grow and flex its muscles and review and limit the role of non-state actors. And there has been even questioning of the role of intergovernmental organizations, which of course limit the scope of power of independent states. Think of Brexit. So irrespective of ideology, let us then focus on what is or is perceived to be wrong with ISDS. And again, please read this to mean simply investment arbitration. Some key data first. We have, as of the end of 2019, some 1,020 plus non-ISDS cases. And you see that although the ISDS system is supposed to be the result of decolonization and has a political origin which is rather dubious, the growth of ISDS cases goes to the early 90s, or even perhaps the late 90s, when we had an explosion of cases. In these cases, if one looks at the statistics, we will see that in terms of the concluded cases, the vast majority is decided in favor of the states, and less than 30% are decided in favor of an investor. A good number of cases settles or is discontinued, and a number of cases would be ended with finding a breach of an investment agreement, but without damages being awarded. So overall, the states do not fare badly. If one looks at the merits of the cases, then of course that is a slightly different statistic. Now, there's a very long list of what could be sort of the examples of legitimacy crisis, but I will refer only to 3 cases, which I will call, if you wish, the tip of the iceberg. The first case is ACME and the impact of ACME in terms of legal certainty, specifically within the European Union territory. ACME has invested in Slovakia. There's a finding in the Constitutional Court of Slovakia that the investment of ACME has been expropriated. And ACME has initiated arbitration because they thought that that's the best way of getting damages for the expropriation of their investment or the general interference in their investment. So ACME went all the way through the arbitration process and again, having sympathetic decisions in Slovakian courts. But when it came close to the to have the award being able to generate legal consequences and being enforced, the German courts referred a preliminary question to the European Court of Justice. The preliminary questions were phrased in alternative fashions. And because I suspect the Bundesgerichtshof did not expect that outcome, and effectively the Court of Justice aligned itself with a third alternative, and that spiraled the termination of most intra-EU BITs, and indeed the sort of shaky basis of intra-EU ISDS claims. So a case which started from very good reasons, which are technically legally, no one disputes ACME's right, have ended with a rather cataclysmic sort of consequences for legal stability within the EU and not transition discussion. The second case is UCOS. UCOS is being lauded specifically by those who like the decision because of the amount of damages that have been awarded in this case. And I might have to remind you that in this case, the tribunal has awarded $50 billion in damages. Of course, no one says that actually this is only 50% or less than 50% of what the UCOS shareholders requested, because their original claims were in excess of 100 billion. And of course, we do not know what is going to happen in the Dutch courts. In this case, may never be enforced. In my view, UCOS is an interesting case because there's an element of arbitral activism there. This is a case under the Energy Charter Treaty, and the Energy Charter Treaty applied in relation to a Russian Federation on a provisional basis, which meant that the dispute settlement chapter did operate. But for somebody who was not in the case, everyone will identify UCOS as being a Russian company owned by the poster boy of privatization in Russia. And therefore, there's an interesting corporate structure in transferring a lot of the shares of UCOS to foreign shareholding. And that perhaps is something that, in my view, the tribunal did not fully discuss, or I could have seen argued in many different ways. The third case, which is, so UCOS is attached for the level of damages rather than the jurisdictional question. There's much more to be said there. And in the third case of this tip of the iceberg is the Philip Morris and regulatory chill. This case, of course, relates to the Australian plain packaging legislation, which effectively interfered with the use of trademarks of Philip Morris. And of course, the motivation of the Australian legislation was public health. I've never smoked myself. I don't think smoking is good for anyone, but it's a matter of choice after all. We live still in a free world. But it did have certain consequences for Philip Morris. The case did not go very far, and perhaps the decision is correct, the Philip Morris tribunal decision in finding no jurisdiction, because there has been an attempt to change the corporate structures to avail oneself of the benefits of an investment agreement. But these cases are exceptional, are not the normal ISDS cases, and they should be seen as exceptional cases. So when the whole debate about legitimacy crisis started, and one can find this start of the discussion about 15 years ago by a number of academic events, but also a number of reports produced by a number of NGOs and civil society, they eventually culminated to concerns which have been sort of particularly formalized by the European Union. The European Commission has produced a paper which exists in slightly different versions, but in that paper they have a number of what they will call problem trees, and also a number of potential sort of friction points, and what can be done to address some of these friction points. You see, for example, that some of the concerns are confidentiality or the bilateral, but confidentiality no longer exists at a very high level in ISDS. We have a very high degree of transparency. Most awards are being published. So that is something which is perhaps exaggerated. But of course, there are a lot of other points that are there which are quite meaningful. So if one were to summarize what are the key directions of reform, and some of these directions, particularly close to the various EU proposals, one could group them in four categories. One area of reform is ensuring consistency. And let us not forget that consistency is not something that is desired by the EU. Argentina, for example, when they were very successful in a number of annulment cases in 2008, 2010, they were arguing that the key problem with ISDS or investment arbitration is the lack of consistency. How can some tribunals find state of necessity to be of a genuine defense and others do not? It's the same sort of political circumstances where the state of necessity has been raised. And of course, some of the issues of consistency appear when we have contradictory decisions. One discussion which was had about 15 years ago is whether ICSID should have more powers to consolidate proceedings. One could argue that a lot of the Argentine cases, a lot of the Spanish cases are effectively parallel proceedings affecting individual companies, but effectively what is being discussed is the same in all of these cases. And Argentina and a number of other countries, in the summer of 2010, they were debating whether the creation of an appellate body, which could be created on the basis of an optional protocol to attach to the ICSID convention, should be the way forward to make sure that inconsistencies are being addressed in that particular way. The second concern relating to reform is the question of fairness. There are sentiments, there's a high level of arbitral activism in the sense that a lot of tribunals are quite lenient when it comes to establishing jurisdiction, but they may be heavy-handed when it comes to award damages. If you talk to counsel, a special counsel that particularly represents investors, they take the view that it is much easier these days to defend states than it is to defend investors in investment cases, because to substantiate the case is almost an uphill battle that you can never win. And especially counsel that represents small and medium-sized enterprises, they find that there's a significant asymmetry of means or asymmetry of weapons. Even developing countries, when they want to defend themselves, they can't really avail of legal counsel, and they have no, as indeed any respondent in any dispute, have no incentive to accelerate the process or to make it particularly economical. Let the claimant that initiate the case suffer the consequences of that initiation. So the asymmetry of means and weapons is addressed by various ways. One of these ways, for example, is third-party funding. Third-party funding has been seen as a negative aspect of the process because it was used as an argument that, again, of the disruption of asymmetry. An investor with a third-party funding has indefinite means. That's never true, of course, and can drag a state with in a dispute with very expensive in a very expensive process. So how one balances this asymmetry of means, how one makes sure that, for example, a state that participates and is paying counsel has to pay also, for example, the share of the ICSID fee, which often doesn't happen, is one of the questions that is being done, but it's not addressed in the context of UNCITRAL. It is more perhaps relevant to ICSID. Where there's a lot of enthusiasm is the last two areas of reform. One is the question of efficiency. I think everyone takes the view that efficiency is critical. Everyone takes the view that one can perhaps run processes in a much more effective way. And it's quite unreasonable for parties to wait for a long period of time, often 1 year or more, after the final procedural act before they can get the award. And now we know that the expectation is that awards should be drafted within 3 or perhaps 6 months. But again, outliers, very bad outliers, do still exist. However, of course, transparency means that awards that will be published are inevitably much longer. They're not just written for the parties, they're written also for the wider audience that is going to read them. And finally, the final category is that of ethics. In relation to ethics, of course, independence and impartiality of arbitrators and experts is critical and is a hallmark of rule of law and is a hallmark of legitimacy of any system. And I think no one can take argument with that. Of course, the ICSID convention, for example, the way it has been drafted, Article 15, is very limited in what it covers in terms of impartiality and independence and qualifications of arbitrators. But now there is a code of conduct that's been drafted jointly by Ancestral and ICSID. Is being debated and will be debated even a bit later today. But I think there's very little debate as to the legitimacy of such a direction of travel. And finally, again, third-party funding and disclosures associated with third-party funding is the other big category of discussion in this context. So how do these various proposals demonstrate themselves? Effectively, we have a range of five different proposals. One group of people say that the system has worked. If you look at the numbers of cases, the steady number of cases, even when we debate legitimacy, it's perhaps appropriate to do absolutely nothing. I don't think that's a very palatable decision because simply the cat is out of the sack. So we have to really take some action. A second proposal is we need to improve ISDS. That's very much what ICSID is in the process of doing. Take the rules of procedure arbitration and improve them, build in more efficiency sort of strategies and ethics sort of elements, so that ISDS will be improved and perhaps will work much better. And of course, that's quite a desirable outcome. Then we start moving perhaps outside one's comfort zone. And the next proposal is to have an ISDS, but with an appellate system. The idea of an appellate system has come up on and off over the years. The US was proposing an appellate system in 2003. That was rejected as being quite an anathema at the time. Then some of the Latin American states, repeat respondents, suggested an appellate system in the form of an optional protocol to the ICSID convention. I find that proposal quite attractive. I mean, keeping the traditional ISDS, but having an appellate system with a very limited mandate. And that, I think, is a golden compromise, or rose gold, as the slide would suggest, that could perhaps bring about sort of solutions that would be acceptable to the two polar positions. The fourth proposal is to replace private arbitration with a multilateral investment court system, or an ICS, sorry, investment court system. This proposal, which comes largely from the EU, is to build up a permanent investment court system, very much in the style of CETA or other EU free trade agreements. The model, to a large extent, for this investment court system is WTO, and although not exclusively there, and of course, the WTO is a significantly different beast than the investment world. First of all, the investment world operates on the basis of bilateral agreements largely, and very few multilateral texts. Called the WTO is a multilateral trading system. The WTO appellate body has not been functioning very effectively for the last few years, and there have been proposals to have it reformed, but that's a fact. And also another difference is there's a substantive divide at the heart of WTO agreement. So WTO obligations are observed collectively, while WTO rights are exercised individually. And of course, this has two competing visions of justice. I recall about 18 months ago, a very pleasant discussion I had at the Lauterpacht Center with Kios Karmody, who is a WTO scholar in Canada, and has pointed out that the principal type of justice under the WTO agreement is distributive. So in case of violation, justice operates to maintain the distribution of collective expectations, something which explains the direction to wrongdoers under Article 19.1 of the WTO Dispute Settlement Understanding. So what under WTO you do is you require that the laws are brought into conformity with the WTO agreement. And in most instances, conformity involves withdrawal or amendment of the offending measure, action which results in re-establishment of the equal distribution of expectations. So that would be completely unacceptable under the investment system. We would never accept a specific performance which will mandate that the state change a law that they have taken. Where does regulatory power and police powers goes? At the same time, of course, in WTO, there's a second type of justice, and this is a corrective one in the sense that the aim is to repair the harm done. The harm occurs because countries exercise their individual rights to take action that, strictly speaking, may disappoint expectations. Over time, the interaction of rights and obligations under the WTO agreement produces a regime of law that can be described as lex specialis, and is very technical indeed. So the combination of is a special law because in many circumstances, it does not conform with the normal consequences of a state responsibility. And justice in this mode is transformative because it does not speak, it does not seek to distribute expectations or to correct harm exclusively, but rather to resolve conflicts between national interests in a manner that develops and strengthens relationships among those involved. The fourth solution is to scrap everything and leave everything to national courts. Of course, that is the dreaded repoliticization of investment disputes. And in so many ways, that would not be a very attractive proposition. So in order to establish what works and what does not work in these reforms, and before I delve fully into my philosophical debate, and particularly Greek political thought and Greek legal philosophy, if I may be excused to do so, Queen Mary has accepted an invitation by the Corporate Council International Invitation Group to do a pioneering ISDS survey. So the idea was to explore what investors think about ISDS as it stands, and also what they think about investment agreements more generally, but the focus was on what they think about the current reform agenda. So we were very concerned not to limit ourselves to major multinational organizations. So the responses come 62% by multinational organizations and 38% by small and medium-sized organizations. Of course, the evidence is perhaps a bit skewed towards multinational organizations for a very practical reason, because these organizations are much bigger, they have institutional memory, and they have a big legal department which has continuity, while sometimes small and medium-sized enterprises rely heavily on outside counsel. And in our survey, we excluded every response which did not come from an in-house team. We also tried to cover a very broad area of operation. So we have, of course, a good response from Western Europe and Southern Eastern Europe, but also North America, Latin America, Sub-Saharan Africa, Middle East, Southeast Asia, and East Asia. So this can be seen generally as a global survey. So you'll see that 80% of the respondents are legal counsel, head of litigation, or head of legal or general counsel. And there's, of course, nearly 20%, which could be either management or business commercial manager, or people in a lead management position in the organization. We also try to cover a very broad area of industries, while just over 16% is electricity, gas, steam, and air. We have very good responses from also manufacturing, mining, transport and storage, public administration, defense, construction, of course, and also information and communication technology. So one could see that most of the industries are reasonably represented in the responses, and that actually makes the results very rich indeed. So I will just pick up a few of the responses, and a lot of them will be debated in more detail and perhaps with much more authority from our roundtable of in-house lawyers. One of the key findings is completely unsurprising. If you ask, and that comes very clearly from the interviews, no one likes disputes. No general counsel would be keen to be involved in a dispute. But if they were to be involved in a dispute, they would like to be involved in a dispute that they can design themselves. And therefore, a contract-based traditional commercial arbitration is much more desirable than a treaty-based BIT arbitration. So there's no opportunism in the dispute, but they want to have a dispute design which meets their requirements and keeps them confident. Now, on the reverse, you would see that litigation in the host state countries is the least desired option. And again, government intervention, some sort of diplomatic protection is not particularly popular either, as is the case with direct negotiation between investors and state, and in some cases mediation. Of course, there are instances of very successful investor-state mediation, but the feeling amongst investors is that a lot of these negotiations with states are almost futile, because the state will never negotiate in a fashion that will be prepared to give a cash payment to the other side, and there's no one in the government prepared to sign that paper. But of course, a lot of states are prepared to engage in some sort of a discussion. So mediation works only if it is an interministerial committee, or even if it's a post request for arbitration initiated. So what else we have seen in our survey? When one looks at to what investors seek in a jurisdiction where they want to invest, it's not ISDS, which is the primary concern, but the primary concern is the predictability and the stability of the legal environment. So these results are more or less equal. So they want to have an environment, even if it is risky, but is reasonably predictable and reasonably stable. And if it's not very favorable to investors, they will price the investment accordingly, and it will become perhaps a bit more expensive for the host state, in the sense that they will require a longer concession rather than a 15 or 20-year concession if they want to balance that lack of stability. And of course, contract-based protections comes next. So ISDS is in the top 5, but is not, sorry, is in the top 6, but is not in the top 5, or 5 and 6 are joined in the same place. So again, it's a very pragmatic view expressed by in-house lawyers. And looking at various commonly accepted ISDS perceptions. So again, dark blue is where the strong agreement and light sort of lilac, perhaps is the color, is strongly disagree. There, what we see is that investors take increased political risk into account in making decisions. That's part of doing business. Risk is being assumed. And of course, the ability to appoint experienced adjudicators is important to disputing parties' confidence in the ISDS process. These are perhaps the two positive aspects. And when it comes to the negative, we will see the top one, investment treaties without international dispute resolution mechanisms are attractive to investors, as would be a protection that they receive from domestic court. Strongly disagree, 60%. Some would disagree, 27%. So nearly 90% would not agree with that. And if we're to look also on the third bar, the reforms to the existing system will change the risk profiles of each state involved. And again, we have strongly disagree, 60%, or some would disagree, again, 2/3. They think that risky countries will remain risky, irrespective of what the law or the treaties appear to be. So I have already mentioned in my preliminary comments that that consistency and efficiency are the key drivers in the reform process. And very, very clearly we see there that they think that consistency can be improved. The results are 78%. Efficiency can be improved. That's even stronger. That is 83%. So that's where the investors see the scope for work to be done. And I think they're engaging in many different ways. Finally, one of the sort of preliminary issues, what is happening with the proposal for a multilateral investment court system or investment court system and sort of arbitrator selection generally. There, again, the lilac color or sort of would be damage confidence, while the dark blue will be, or sort of almost royal blue will increase confidence. A mandatory arbitration list developed by states would damage confidence significantly. And only 21% finds that they will increase confidence. A standing international arbitration court with permanent judges nominated by states alone, 56% would damage confidence, 26% would increase confidence. So you see that investors take a rather pragmatic view, and they're prepared to see what are the options. Appointments made by an intergovernmental organization, 48% sees that as a damaging, 35% as a positive solution. A mandatory arbitration list developed by an institution with equal state and investor representation, that's seen very positively, or quite positively, and mandatory arbitration list developed by independent institutions, the ICC, ICSID, etc., 47%. So that's even more strongly supported than the previous one. So the investor views is that the creation of a multilateral investment court system, which would replace arbitrators, 30% would favor it somewhat, 8% would favor it strongly, but 56% would oppose it either strongly or somehow. And we will see that 33% will use the multilateral investment court system if there's no alternative. 28 likely to use it even if there was an alternative. So that comes to over 50%, 60% almost. And unlikely to use if there was an alternative, 20%, and unlikely to use even if no alternative, 8%. So I think investors accept that the discussion is moving, and they want to keep their options open because they want to be able to assess what is the best option for them in the appropriate circumstances. So the two final slides I would be presenting, statistics I would be presenting. One is that the feeling is that third-party funding should be available not only to impecunious investors, but also to investors that make a decision, the commercial decision to fund their cases, and therefore one should not assume anything in the existence of a third-party funding, and therefore perhaps the debate about third-party funding should always mean security for costs is controversial and will continue to be controversial for some time. And in relation to mandatory mediation, you will see that 33% opposes strongly or somehow, and 30% strongly favors, and 34% somehow favors. Perhaps the reason for the skepticism about mandatory mediation is that unless there are good sort of checks and balances about how the mediation process would be conducted, and unless the state fully commits to that mandatory mediation process, it might end to be effectively a pure dilatory tactic. The survey, of course, looked at a few other topics. It looked at the question of an advisory center for ISDS that is perhaps quite advanced at the moment within the ancestral discussion, how arbitrator selection should happen, the code of conduct, and indeed the introduction of an appellate body and the sort of the way the appellate body will be constituted. So what do we see from these results, and what we see from the data that the pre-Queen Mary CCIAG survey data? As I have already told you, my analysis will be very much focused on legal philosophy, and I have used the School of Athens as a background. One might have seen recently the unveiling of that in the French Assemblée Nationale. Of course, the entire Greek political thought, and of course Socrates and Plato that you can see there, and Aristotle somehow in the side, revolves around the important concept of justice. And this is a rather abstract concept and is difficult to define in any fixed terms, as it is viewed differently by different thinkers. But for Aristotle, justice is of two types. So there is universal justice and there is particular justice. The former, of course, refers to obedience to laws. The one should be virtuous. You should do the right thing. As far as the particular justice is concerned, this is again two types, that it can be either distributive justice and remedial, or it could be a corrective justice, terms that I have already used. Distributive justice implies that the state should divide or distribute goods and wealth among citizens according to merit. And remedial justice is divided into two. If we have voluntary transactions of a civil law type, and the dealing of involuntary transactions, so criminal law matters. And he also sort of added that commercial and cumulative justice are related that way. So the WTO model of distributive justice, Aristotle is one of the opinion that this form of justice is the most powerful law to prevent any revolution, as this justice believes in proper and proportionate allocation of offices, honors, goods, and services as per the requirement of being a citizen of the state. So this justice is concerned with political privileges, and he advocated that every political organization must have its own distributive justice. He, however, rejected democratic as well as oligarchic criteria of justice and permitted the allocation of offices to the virtues only owing to the highest contributions of the society, because the virtuous people are few. That was his view. Therefore, most of the offices should be allocated to those few only. That perhaps even explains why we have very few, the pools of arbitrators, etc. So we'll not go down very well in the world when we talk more about diversity and increasing the pool. But there you go. In terms of corrective justice, all laws that relate to commercial transactions, perhaps investment disputes will be in the same category, are dealt with remedial or corrective actions. they aim to restore what an individual had lost due to the injustice of a state or society. This justice prevents from encroachment of one right over the other. So he opined that corrective justice relates to voluntary and commercial activities such as hire, sale, fencing, security, and in that sense also investment for our purposes. So these actions involve aggression on life, property, honor, and freedom. And in brief, this justice aims at virtue and moral excellence of character, and it is for that reason that is called corrective justice. So the principal source of Aristotle's theory of justice is Book 5 of Nicomachean Ethics, a book that it is a companion to and proceeds his politics in an expository order. The ethics is essentially an inquiry into the nature of the good, human life, and especially into the virtues that are integral to it. His theory of justice is couched within this, and for him, much larger frame. So perhaps a very good exposition and perhaps a more popularized exposition of all of this theory comes from one of my favorite books by Martha Nussbaum, a book called The Fragility of Goodness. So because we have to distinguish between complete or general justice and partial or particular justice, we call things just which produce and secure happiness or the parts of happiness for the political community. Justice in this sense is complete virtue or excellence in relation to one's neighbor. So that is effectively what he is directing us to. So it is the only virtue that seems to be another person's good, for it's related to another, for it does benefit the other. So partial justice or particular justice, which is the classical justice we know, I mean, WTO would aim at this complete justice. So sort of restoring a distortion on the trade system. And it becomes an attribute of character, a virtue that is exhibited by human and states being in the relationship with others insofar as they interact and they want to promote a good life and happiness for everyone. But the particular justice of the ISDS has to do with the share of benefit individuals should receive and of burdens that they should bear. Among the benefits with this partial justice is concerned, he mentions material goods, security, very much language that in some way translates in investment agreement. And although he emphasizes not just the benefits, but also the burdens, the obligations of the investors, he says because investors have obligations, they also have benefits. So this is effectively a departure from Plato because Aristotle wants to bring about that concept of burden obligations of investors and not just rights. And I shall follow Aristotle for this analysis by focusing in his theory of particular justice and what he will call justice rather than just the concept of rightness. So the larger context of this discussion is provided by the idea that the complete justice is almost unattainable, and it's a much broader international relations debate. So I would apply the label justice to the topic, dropping the more cumbersome partial justice term for the second part. So what he argues, therefore, is that ISDS, I would submit, is a justice system, is a system of particular justice in the sense of recovery. Of course, the other aspect of the Aristotelian justice theory is equity. Equity is justice in what it goes beyond the written law and is equitable to prefer arbitrations to the law court, for the arbitrator keeps equity in view where the judge looks only to the law, and the reason why arbitrators were appointed was that equity must prevail. And that's again the original language. So what then happens and why we have seen some sort of, why this is not much more prevalent in our debate. The reason perhaps why Aristotle is not much prevalent in recent debate is because there have been a couple of departures from that theory, and perhaps one of the biggest critics of Aristotle was no less than Kelsen. It was revived by Roscoe Pound at the beginning of the 20th century, but then Kelsen, in his book Was ist Gerechtigkeit, What is Justice, in which he attempts to show how and why several theories of justice formulated by authors from ancient Greece to European Enlightenment are wrong. He addresses particularly Aristotle and his Nicomachean ethics, and he argues that Aristotle's concept of moral justice is flawed in that it merely aims at justifying social norms of his time and is hence tautological. Of course, the response to Kelsen is given by a large extent, in my view, by Martha Nussbaum. Aristotle is clear that moral virtue is good if it is in accordance with reason, with logic. For Aristotle, justice has the two meanings that we said, the obedience to laws, but also the fairness. Virtue is coextensive with gain and has to do with obtaining gain at the expense of others. Justice is fairness, justice is virtue and equity. One can get, of course, a better reading of Aristotle if one to see how Aristotle will decide Acme, Philip Morris, and Eukos. And I would argue that certainly he might not have agreed with the tribunals in all these cases, and therefore aligning a model which is perhaps more sophisticated than what we have done. So can a better reading of Aristotle's concept of justice also agree with the current reform agenda? One's clear intention of current reform proposals is to transform ISDS from a corrective to distributional justice. And would that mean more or less freedom? And would that mean more or less justice? My concern is that the debate continues to be ideological rather than rational. So the teleological expectation of Aristotle is not met here, but also the fact that the reform is piecemeal, only focusing on procedural reform, and whoever has attended the last working group 3 session would have seen that quite a bit of the debate was that certain topics already touch substantive protection rather than purely procedural matters. And I would perhaps submit not just substantive, but also jurisdictional matters. And I don't think an international treaty can regulate jurisdiction under the guise of procedural reform. Then my fear is that there will be further fragmentation and more scope for inconsistency. And that's not certainly what is desired. So, and I wonder whether ideology could or should be presented as a centerpiece of reforms, and if ideology and perhaps philosophy and theory are being put at the centerpiece of the reforms, we might achieve better results. Thank you very much.
Thank you very much, Professor Mistelis. That was very, very thought-provoking and interesting. We are now going to move to our panel discussion. Just a word on the questions before we do so. So please pose any questions you have in the Q&A box. We have a couple there already. Thank you for those. I'm not going to pose them right now. I will weave them into the discussion when is a good time. Because I think it is going to be benefiting everybody to get the views not just of Professor Mistelis, but also our panelists on these questions. Please don't just say I have a question or put the waving hand sign up. Because we're trying to keep this quite a structured discussion, it is useful for us to actually know what the question is, so that we can address it at the appropriate time and in the appropriate reform. But let's first move on now to the panel. And of course, the key issue about our panelists today is that they are the users of the system. They are in-house counsel of companies that have experience of investment arbitration. So we are therefore all very interested in their views on the matters that have just been raised. And if anyone who is interested in ISDS and reform of the arbitration system is not interested in the views of our panelists, then I think that is a major problem. So let's get to our panelists. And I'd first like to ask you just to give your initial reactions to the lecture and the results of the study. Is there anything in particular there that struck you? And if we go in, let's go in alphabetical order. Ninke, would you like to address that first, please?
Yeah, sure, of course. Thank you very much, Laura, and thank you very much for EFILA in the first place for organizing this annual lecture, and especially also for Professor Mistelis for his great insights into the investors' perceptions of ISDS, and also the very interesting reflection on Aristotle's vision on justice. I think that was very thoughtful and very interesting. I think the survey of Queen Mary, University of London, as well as CGIAG, I think it's a great piece of work that can contribute greatly to the further strengthening of ISDS. Thanks also for giving the investors a voice in this broad international debate. I think it's really good to have this topic and to keep this topic alive. So, well, I think I'm amongst very good, scholared and valued panelists, as well as yourselves, Laura, and Professor Mistelis and Nikos. Great to have you all here. You asked me, Laura, for my first initial reactions to the lecture and the results of the studies. Well, as being one of a user of the system, I very much recognize the underlying positive elements that drives ISDS in its current form. But also looking also at the survey, I think there's room for improvement in the system. I thought the problem tree that was presented by Mr. Mistelis, I thought it was very interesting. The question I had there is whether the alleged drivers that the EU has defined really results into these problems as they were described, and of course, and I think we're all in there together, is what the appropriate answer should be. And I think if you have to talk, and we are talking about the reform discussions on ISDS, particularly also in light of the current European BIT discussions, I think that should be done with all stakeholders involved, with an aim to protect all interests of all parties, and that means states, that means investors, that means big investors, that means also SMEs. Because I think, after all, trade and investment treaties, as well as ISDS, have been pillars of not only Dutch, but also European and worldwide foreign economic relations for over 100 years. Even after the Second World War, they've given new impulse to economic developments. They promoted the BITs, promoted direct investments, have been considered intra-EU. And since then, I think all member states in the EU, both the older but often the younger member states, have been able to reap the benefits thereof, as well as the investors. Looking at the report, I think it perfectly makes sense that that the report concludes that from an investor point of view, contract or treaty-based ISDS is still highly valued if you compare it to other dispute resolution mechanisms, such as well, what was described the host states courts. The more sadder it is, speaking for myself, and you will all recognize that, is that, well, as a consequence of the incomprehensible ECJ judgment in the Acmea case, and subsequently, as we feel it, the hasty entering into determination agreement by several EU member states, I think ISDS is, at least in Europe now, considered to be in a legitimacy crisis. And the question is really, well, how to deal with that, because the BITs are in the verge of being terminated. And at the same time, if you ask investors, they value it still very important that there is a contract-based or a treaty-based arbitration system. So I think the survey really summarizes nicely the most important factors to protect ISDS, and that should be in the heart of a reform of ISDS going forward. And that's basically legal certainty and legitimate interests, legitimate expectations. Well, it's one of Professor Mistelis' tips of the iceberg, but I think that's really at the heart of legal protection. I think the quality of arbitrators and awards is also one of the important backbones, of course, of ISDS, knowledge, experience in the industry, and countries as being key elements. I think that's also really important. That also came clearly out of the survey, as well as maintaining speed and time and cost efficiency of the process, taking also into account the neutrality, the impartiality of the arbitrators, and the ability for the parties to appoint arbitrators. So I think there are a lot of factors that came out of the survey that I very much recognize. So maybe a broad view, Laura, but I think that there's a lot that comes out of this survey, that I recognize, but I also agree with the outcome of it, that there's still room for improvement on several levels. So that's for now. My first presentation.
Thank you, Nienke. That was interesting. Victor, do you want to give your views?
Yes, of course. Well, thank you. I would like to thank the EFILA for the invitation, and thank Professor Mistelis for the magnificent lecture. It's really enjoyable, really thought-provoking. And I just wanted to jump in on some of the issues that were already mentioned by Nienke. I do believe that the report, it's a great instrument for all in-house counsels that have to deal with ISDS. But nonetheless, since the specific focus of the report or the inquiry was inside counsels, I think that the results are not something that we would have not expected. It's obviously that this reflects the investor side of this business. However, I would like to mention that one of the issues that I saw, and I'm glad that the results show this, it's the issue of transparency and stability, which is obviously something crucial in the moment to take into consideration to go into a new investment, a new jurisdiction, and it's well reflected how this is important for investors at this stage. The other thing that was kind of surprising for me, at least, is when assessing the possibility of the multilateral investment court, which at first glance, it seems that most of the people that were part of the survey do not agree. But when the question shifts, if implemented, would you participate? It seems to be a shift in the balance of the answer. So obviously, I think this obeys some logic that you're not going to leave your client without recourse to any mean or any source of access to justice. But it's interesting how these two questions interact in the report.
Absolutely, that is, I suppose, going to show that yes, that the investors are in any event invested in the system, and they will take part no matter what the format is, even if it is something that is not their first choice. Tom, you have of course a dual role of being in-house counsel yourself, but also you have perhaps a broader view on some of these because of your work with the CCIAG. So what are your initial reactions?
Well, thank you very much indeed, and thank you for allowing me to participate and to represent the Corporate Counsel International Arbitration Group. My first reaction is I'm delighted we're talking about this because this is, in fact, so important from a global perspective. The investment treaty system is there primarily to promote, facilitate, and encourage investment. And the generation of our parents and grandparents recognized how critical investment is to development. In fact, UNCTAD has estimated that 38% of gross domestic product arises from foreign direct investment on average. 38% of GDP, that is an astounding number. For instance, 45% of new jobs in 2018 in Mexico arose directly from foreign direct investment. So foreign direct investment is tremendously important for development, and an investment dispute mechanism is tremendously important to maintain investment. That is what we're talking about here. This system has been carefully crafted by the post-war generation with the New York Convention being put in place, and then the Washington Convention being added, and has been carefully developed over the past almost 80 years. It has worked in a sense that it represented a certain balance between disputing parties that was carefully crafted. Now, we are very thankful and appreciative of the leadership of Professor Mistelis in doing this study, because, for instance, some state representatives had taken the public position that investors do not support the existing system, and they would support replacing it with a multilateral state-appointed investment court. And so we fundamentally wanted to check that proposition. And the result of that study is quite clear, that it defeats the proposition that investors support an investment court. They do not. They clearly do not. If they were forced to, because a court were to be created, they would have to participate, because they would have to defend the rights of their clients. But if they had a choice on whether or not such a court were created, I think they overwhelmingly would prefer to stick with an improved existing system. So it seems that investors are generally in favor of reforming the system to make the system more efficient, more workable, but they are not in favor of effectively structurally destroying the existing system and replacing it with something completely different that would have effectively redone the work of multiple generations that had carefully crafted the system that we have now. I'll stop here.
Thanks, Tom. We will probably come back to some of those issues that you've raised there in more detail later. But let's start one of those, which is, of course, this aim that should be at least one of the key aims of investment treaties, which is to promote and attract foreign investment. And this issue goes also partially to a question that was posed by Andrew Clark. Now, do the investment treaties do that? What are the important considerations for you when your company is thinking about investing in a country? And do the BITs even matter for this decision-making progress? And then the follow-up from that, being assuming that it's yes, is would any of the proposed changes to the BIT regime make it more or less likely for your company to invest? Tom, would you like to follow up on what we just started there on that question?
I'm happy to start. So we're in the energy business, and so we are forced to go and invest where oil and gas can be found. All of us would love to invest in Switzerland, but God had a sense of humor and simply didn't put any hydrocarbons there. We have to invest in places where hydrocarbons can be found, and many of those places, unfortunately, are places where there isn't a very well-developed legal system that's stable, predictable, neutral, and open. In those circumstances, having the additional protection, in addition to contractual protections such as stability clauses, which are incredibly important and incredibly valuable, but in those circumstances, the additional protection of being able to enforce our rights beyond the contractual enforcement mechanism by way of a treaty enforcement mechanism are quite significant. I've participated in countless investment decisions over the past 20 years as in-house counsel, and in every one of them, there was a specific discussion about what is the scope of treaty protections for that jurisdiction, and if the contract itself does not give us confidence in the ability to protect our rights, would we invest in the absence of appropriate treaty protections? So treaty protections are very much taken into account.
And have you then been party to discussions where the reforms or the proposed reforms have come into that, saying that, okay, we will invest in this country because it has this sort of a BAT, but if it's changed, then that kind of metric or that consideration might change? Or do you think that's something that discussion to be had in the future when it is an actual state of affairs rather than something that's just a proposal?
Well, I think those types of discussions will only occur once the reform process matures into some level of predictability as to the substantive reforms that will be chosen. At this point, the reform process is somewhat inchoate. I will add one more point, which is that it appears that many of the states were unsatisfied with the substantive protections that they had agreed to in their investment treaties. The specific substantive protections such as fair and equitable treatment or indirect expropriation, which are inherently very flexible. They were meant to be applied in various circumstances. And so there was some level of dissatisfaction with the flexibility, or as some would say, the lack of precision or the vagueness of the substantive protections. And the states are attempting to remedy that dissatisfaction with the substantive standards by way of a procedural reform. There's a bit of a mismatch right now with respect to the issues that can really drive the states and concern them, and the nature of the reform that is being promoted. And there's almost sort of a humorous aspect to it, where you say, well, we don't like the way these decisions are coming out, so we'll just give you a new set of judges, and that'll solve the problem. I'm obviously being facetious, but there's an aspect of the multilateral investment court proposal that really reflects that. We're not going to change the substantive protections. We're going to change who picks the adjudicators. So we'll just have to see how the reform comes out.
Thanks, Tom. Victor, you're also working in the hydrocarbons industry. Are the considerations similar when Total thinks about investing, or is there something else at play?
Indeed, very similar. Always the BAT protection comes into the table. It's always considered, and it's always a plus. So, as Tom said, to the extent that you are able to secure solid contractual background, you're good. But if you can't get both, it's the best case scenario. And another thing that I have seen is depending on the kind of investment you are going to be involved in, there might be, because, for instance, if you're thinking about investing in an offshore project, you have another set of issues to take into consideration to see if there is any boundary disputes which might affect the area into which you are going to invest. So the oil and gas industry has provided a lot to the system, because obviously many of the disputes are related to this industry, and there is still a lot of room for improvement and to grow within the system and the industry in order to, to provide the most adequate protection or the most adequate consultation in-house to our clients.
Thank you, Ninka. Now you are in a different industry, but you of course still, unfortunately, have the honor of being well known. Well, your company has the honor of being well known in this field for not the greatest of reasons. Now, since you've had, I'm just going to guess that Achmea has had not the greatest of experiences with investment treaty arbitration. Is the existence of BITs something that Achmea still thinks about when investing, or have you given up on the system?
No, not at all. Well, it depends on how it further develops, of course, but thank you, Laura. No, we do have investments in other European countries, but also in Canada and in Australia. And of course, if we are to invest in a foreign country, we of course look at some important essentials of a country, and Tom also touched upon that. I mean, legal certainty, the legal environment, the stability of legal environment is of course very important. Predictability, but also the political environment is of course important to look at. Has to be stable, and if you look at the bilateral investment treaties as they were concluded, well, for years, the basis of them was really to give investors an extra incentive and extra legal protection for their investments, particularly in states that are either were developing or still had a legal system that wasn't that much developed, but they still wanted to encourage the investments in these countries. And it was both, well, in our case, of course, the Netherlands, but also the receiving states thought it was important to have these investors on board and to give some trust in the system and the contract that they could, or treaty that they could rely on in case of, well, any situations and any discussions between them. If you look at BITs, yeah, I think they still do matter. We of course have this unfortunate judgment of the European Court of Justice that basically pulled the rug underneath Achmea, but also a lot of other investors within the EU. But they are still very important. Fortunately, there are still a lot of other BITs with third-party countries, but they have been the backbone of billions of investments, and I think they will remain to be that important. Not only because of the procedural protection, but also, as Tom says, it's also the substantive protection that is also offered in addition to, well, protection on the basis of EU law or any domestic law. So yes, and to be honest, before investing in the Slovak Republic, it was one of our considerations. Basically, we got the confirmation from the Slovak Republic in writing, so to speak, that the BIT was still in force in effect. Well, we know where we are now, but at the time of doing the investment, we just got this confirmation. But yeah, things can run strange. But answering your question, yes, BITs are still important. An additional form of legal protection, as Victor also describes it, is important. And the sadder it is that especially within Europe, and I'm not talking about ourselves, but also for all other EU investors wanting to invest in another EU country, well, these arbitration clauses are terminated with retroactive effect. The BITs in themselves are on the verge of being terminated. This really has a massive effect. And looking at third country investors, or third country investors, I think we are really put behind now, and it's in a way a distortion of competition, so to speak. If we compare ourselves, for example, with the Chinese, Middle East, US or UK investors in the EU, because they can still rely on BITs. So yeah, we will think once more before investing in both an EU country as abroad. And I think that is really sad and very detrimental, so to speak, for the further development of the EU. So
yes,
that's what I would like to add to the previous speakers.
Yes, and that's very interesting, and that is, of course, one of the reasons why we are here. Is our impression at EFILA is that investors have not been sufficiently heard in the reform process. So it is the survey and the conversation that will hopefully follow from it is long overdue. But if we look at now the reforms, the reform proposals that have been floated, of course, the aim of any reform should be to make the system better. And Professor Mistelis has identified 4 such potential aims: consistency, fairness, efficiency, and ethics. And I'd like to focus on a few of those, starting with consistency. What reforms would you like to see to improve the consistency of investment arbitration decisions? Tom, would you like to start on that?
Sure. Well, I guess there's a preliminary question, which is there a problem with consistency of arbitral decisions? As Professor Mistelis noted, there's been over 1,000 decisions out there. And when we think about decisions that are inconsistent, we think about the Lauder case. There are 2 cases arising out of the same set of facts, however, under different treaties that came up with different results. But that's 2 cases. Generally speaking, decisions have been remarkably consistent. And really, it's a fine balance between 3 aspects: correctness, consistency, and efficiency. And the emphasis has always in the system been on correctness. Because at the end of the day, we are adjudicating a dispute between a particular host state and a particular investor on a particular set of facts. We want to make sure we get that right. That is in part why the current system is an ad hoc system. We want to have the right adjudicators for the right dispute with the right sets of experiences and qualifications. And that decision is non-precedential. It only applies to that set of parties and that dispute. So in terms of consistency, the reform that we would not like is the creation of some sort of an appellate court created in the name of consistency that would, first of all, tilt the balance of dispute settlement against investors in a manner similar as the investment court, because there'll be a fundamental question of who appoints the adjudicators to this appellate court. Second, such an appellate court, in the name of consistency again, could make erroneous decisions precedential and therefore permanent. Even if a decision in today's system is incorrect, it applies to 2 parties for a sole dispute. Imagine the problem created if a wrong decision incorrectly decided would become precedential for the entire system for eternity. That would be a terrible cost. And third, an appellate mechanism created for the sake of consistency would have significant, I would say, unacceptable results of increases in the cost of duration of proceedings. The cost of duration of proceedings is a huge issue already, particularly for small and medium enterprises. When we're talking about 7, sometimes 8-figure costs for a party, they are also an issue for developing states. They're a significant burden for the budgets. Would we want to create a system that effectively could double the cost of all the proceedings and double the duration of proceedings that already are taking 3 to 5 years? And in my particular case, one of my proceedings took 11 years. So would that be an acceptable situation? Let's remember that in the current system, 51% of the ICSID awards are now being challenged, but only 3% are being annulled. And so I think the fear is that in the name of enhancing consistency, which was never really a significant problem, we would unacceptably derail the entire system.
That's a very, very important viewpoint, Tom. Thank you. Does Nimke or Victor want to add anything on this issue of consistency?
Just something short to add to what Tom was just saying. I also think that an appellate system does not really respond to the consistency or perceived lack of consistency in the system. But I fully agree with Tom on the increase of costs. And what we should not forget is that even if there were an appellate system, we still do have the setting aside procedures in the countries where the awards can be challenged. So that would mean that if you have an arbitral award and it will be appealed, then subsequently you can still be confronted with a setting aside proceeding in one of the other countries involved, which leads to indeed an extreme burden in terms of costs. So I would also be concerned, and if it's under the name of consistency, I question whether that is indeed necessary. It could be for other reasons, but I think costs and timing are big issues here.
Thanks, Nimke. Victor, do you wanna add to that?
Just one final point. Since we already talk about this appellate body in the name of consistency, for me, what it is, it's amazing. It's to imagine the creation of an appellate body in the name of consistency. So one could imagine the level of scrutiny and the powers that must be granted into this appellate body in order to go and review the award in order to make it consistent with, I don't know with what, because the system itself is not designed under that premises. So, and that's one of the things that you get when you go into ASDS. You know that there's no precedential value and that the decision is going to be applicable to your case. So that's one of the things that we need to be aware of and make our clients aware of once they take the decision to go into the system. But in my view, an appellate body is not going to help in any way for the consistency of the system.
The second point I wanted to address was efficiency, and I think we have already started on that, because of course these are very much factors that go into less efficient proceedings. But are there some reforms that have been bandied around that you think are useful because they would in fact increase the efficiency of the system? Tom, what do you think?
So I wanted to mention 2 reforms. One of the reforms actually goes back to consistency. So I apologize for going back to your prior question, but there's been a very interesting proposal by some states, including I believe Morocco, that we ought to have prior scrutiny of awards. In other words, an award before being finalized ought to be released to the disputing parties for their comments. I think that is a very interesting proposal, because I think the ability to comment by the parties on the draft award would go a long way to eliminate many errors or many issues that could be presented in a final award. So we strongly support such a mechanism. Going back to efficiency, the issue with efficiency is twofold. Number one, many of the cases are immensely complicated. There are complex, very rich sets of facts and complex legal questions. And second, certainly respondents have no particular incentive to rush through a case that might result in a material judgment against them. So cases take a long time. But an appropriate, I think, reform would be an expedited procedure for simpler and less significant in terms of amount of money cases that would particularly be beneficial, I think, to small and medium enterprises that have smaller claims. You shouldn't have to spend 10 million euros, putting on a claim if it's a claim over 20 or 30 million euros, and you shouldn't have to wait for 5 years to get to a final award.
Thanks. Ninke, any reforms that you would like to see to improve efficiency?
Well, not particularly. I find it interesting indeed what Tom was just suggesting. I mean, to expedite procedures and to formalize them a little bit more may really help in facilitating the speed of the process. So I think that's an important suggestion. In terms of, but it's also again coming back to your previous point is consistency. The question is really is there also an issue if you look at the background knowledge, the actions of I think if you compare it with the domestic legal system, domestic court system, for their experience and their knowledge, both in the relevant industry, but as well as in arbitration field itself. So I think what maybe could make the process even better, or could put some emphasis in some further reform is indeed the selection of arbitrators. The information that we have on all arbitrators, it's also touched upon in the survey. I was just thinking, could we do something more with digitalization, artificial intelligence in terms of judgments, arbitral awards? I think there's much more that we can do in assembling all relevant information, both on arbitrators as well as on awards, that can improve the consistency. Looking a little bit at the advisory center. The advisory center, of course, you can model it as you want it to be, but I think an important factor is also in digitalization, artificial intelligence, combining all the relevant information, and that can be put together in an advisory center. But I think that can also help, both maybe in terms of consistency, but also in terms of efficiency. If you got all the information, all the relevant information together, and maybe it can even speed up the process of appointing arbitrators. I don't know, but just some thoughts.
Thank you. Victor, any further ideas from you?
I think there's one idea that was mentioned by Professor Mistelis during the lecture, which was related to the potential consolidation of cases. I think he mentioned the examples of Argentina and Spain. So that might be another idea that might be further reviewed. But I do agree with Nimke, the gathering of the information or the availability of information will be greatly helpful in order to improve efficiency in the system.
Great, thanks. Now, the third of these reform aims was, of course, fairness. And in this regard, I would move to a question posed by Todd Weiler, which gets into this. And I would also ask Lucas, for your comments on this, because this arises from something you raised in the lecture about the asymmetry of means. That is not so much about the big corporations against public interests as crystallized by the state, but SMEs face a host of impediments in the existing process. That there is very little in the views of Mr. Weiler in the most popular proposals that would actually improve the lot of SME investors when it comes to dispute settlements. So what could be done to address this real asymmetry problem in ISDS? This is something, Tom, you already touched upon. So I don't know if anyone has ideas on this.
Perhaps, Laura, what I could add is that this is not something that we have delved into the research, because the Queen Mary and CCIAG research looked very much at the reform proposals that were put out by Ancetral primarily. But I have done, as part of my teaching, research in identifying who are the investors. And what is very interesting is that the majority of the investors are one-off claimants. There are very few repeat investors, and very few cases comes from multinational corporations. So it is indeed the case that even individuals, but also small and medium-sized enterprises, the majority of the renewable claims in Spain, for example, come from medium-sized enterprises that could get a small loan of a few $100,000 or even a couple of million. So they're not to set up wind turbines or solar panels. So it's not always very, very big. And it's a misperception that the system is driven by multinationals.
I would add that I agree with Todd. In fact, the concern is that some of the potential reforms are, directly adverse to the interests of small and medium enterprises. For instance, there is a discussion about the possibility of banning third-party funding. Now, to me, that's a pure access to justice question, because a small enterprise can never afford to mount an ISDS claim. Another such aspect is a discussion about requiring a security for costs when the claimant does not appear to be extremely well capitalized. Again, that goes directly against small and medium enterprises that do not have the balance sheet of a Total or ExxonMobil. So I wholly agree with Todd, and there is a set of concerns that have been identified by Ancetral Working Group 3 that deal with the cost and the duration. If we were to achieve meaningful reform on cost and duration, that would certainly be in the interest of small and medium enterprises. But we have not dealt with specific reform proposals in that area. I think the states have addressed sort of much more overarching questions, such as whether you have a structural reform versus incremental reform, and they really have not meaningfully dug into incremental reforms that would be beneficial to smaller parties.
Thanks, Tom. Now I'm aware of the time. We have several interesting questions still in the box, but in the interest of not overstaying my welcome and not really stretching the patience of our audience, I'd like to ask a few last questions, which are looking at going forward, and really where do we go from here? And the first one comes from Uni Kim, and this is really looking at the crystal ball, and I suppose this goes mostly to Lucas and Tom, because you were so involved in this study, and the question really is, how do you think, and if the survey will have an impact on the current reform discussions, for example, in the Ancetral Working Group 3?
Lucas, you want to go first?
I can. I think the overall takeaway from the surveys is that the feeling is that first of all, that no system is perfect, but investors seem to have been acutely able to, aware of what is the risk of not operating within an existing system. And I think the feeling is that the existing system, particularly combined with the current investment agreements, creates some sort of a stable legal environment, and therefore is a desirable environment. I didn't have as a takeaway that investors oppose any reform whatsoever, but they simply take the feeling that reform, if it's not done in an incremental or appropriate fashion, if it's not engaged the investment community properly, will increase the risk, and this would have a price, and sometimes states will have to pay that price. That's one thing. But for me, if one takes a meta-analysis of the survey, is that piecemeal reforms do not work. So if one wants to do proper reform, perhaps one should be brave enough and not sort of use the procedural context as the springboard for reform, but look at reform more holistically. And perhaps that is creating perhaps BITs which better represent the current realities. And we've seen countries which did not use BITs, for example, like Brazil. Brazil assigned, I think, almost a dozen BITs in 2019. Not all of them have ISDS, but they certainly started getting into the BIT discussion. So that's the debate that is not being had at the moment, and I think that's what needs to be addressed. Is, by the way, something that I have done as a working group for the T20 this year, and I'm not sure whether we'll reach the T20 as a recommendation.
Let me add on the following basis. I think what the survey stands for is that investors do not support an investment court. I think that that's the most fundamental outcome of the survey, and I think that will cause the states to look carefully at the EU Commission's court proposal. In the end, there are 5 fundamental problems with the court proposal. Number one, it tilts the balance of dispute settlement fundamentally against investors who will change their investment decisions accordingly. Number two, it eliminates party autonomy for both states and investors in the selection of arbitrators, which will present a very serious problem for both claimants and respondents. 3, it fundamentally reduces the pool of qualified arbitrators down to a panel of X, whatever the X is, and it overturns all of the efforts we've done over the past 20 years to broaden the pool and broaden the diversity, both gender diversity and geographic diversity of the pool of arbitrators. So with this single stroke of the pen, all of that is eliminated. Number 4, it introduces a profound uncertainty regarding the enforceability of arbitral awards. Arbitral awards were enforceable under the New York Convention. ICSID awards were enforceable under the ICSID Convention. State-appointed investment court awards would be enforceable under neither of the two. And so you'd have to create yet another instrument which would provide for enforceability. And last, 5th, it provides uncertainty regarding how dispute settlement proceedings are going to be funded and maintained over time, because for those of us who actually sit in Working Group 3, it is absolutely clear that states are not interested in funding a multilateral investment court, and there's going to be a significant debate, one might say dispute among the states over who pays what once again. So for all those reasons, I think this would be the time for states to take a very close look at the potential pitfalls with this proposal.
Thank you, Tom. Since we are EFILA and therefore particularly interested in looking at European developments, I would pose my last question, which is first addressed to Ninke because of the role of ACMEA in investing heavily, in particular in Europe and EU countries. But of course, Victor, Tom, if you have anything to add, please do so. So this is really looking at The Commission proposal, which we of course know is effectively taking away the BITs, which is intra-EU BITs, which is already happening, and then looking at whether something is to be put in its place or whether we just stay with the current system of national law coupled with EU law, with access to local courts, with the possibility of going to the European Court if and when appropriate. Nienke, is there something that you would like to see in terms of additional protection instead of intra-EU BITs, not just the current system of national laws and EU law?
I think there's a lot that we can talk about, but in the interest of time, I will really try to keep it short, Laura. I'm sorry about that. But Tom also triggered me with his rightful concerns towards the multilateral investment court. But that also brings up to me that it's really a pity that this termination agreement has been entered into, if I may say so, so hasty. Because it took away all the bilateral investment treaties with an established arbitration system without putting something in place that works and that comes towards the interest of both the states and the arbitrator. So the question is really what to do in Europe within the EU, and I think that's pretty difficult. Apart from the fact that nobody expected that these BITs were being terminated that quickly. Also, what it does is that parties and basically investors are now requested and forced to go to domestic courts, and in a way that is a very nice idea, but it really is based on the principle of mutual trust of member states. And both in each other's legal systems, and if all these legal systems were as developed as we had hoped, then it could really work. But the reality is that the independence and the quality and efficiency of legal systems, even within Europe, still vary, and they're, well, if compared to the Netherlands, not really comparable with the course of events in the Netherlands. And if you look at the EU Justice scoreboards, I mean, I think that's telling that we are not that far that we can rely on domestic courts throughout Europe. And I think that's really a pity, but I think that's really a reality. So what to do then? And I think also in 2017, the ECOFIN Council already indicated to the European Commission that it was to get some information and explore the possibilities for a modern framework, which made our reinstates an effective and binding resolution of investment disputes. In the meantime, the termination agreement was there. The ECJ judgment was there. I think EU investors are put at a disadvantage, but here we are. I very much welcomed the consultation by the European Commission that was sent out earlier this year, and of course that we gave our view on early September. And in the interest of time, I very kindly refer everyone to the EFILA website, because we contributed greatly to that. But asking at what I think is really important is that there has to be a legal framework that creates the balance of power. I think legal frameworks always shift. Countries need to have the right to regulate. That's of course perfect, but it always has to be balanced against the principle of legal certainty and legitimate expectations, and they can very well function together. So the uniform application of principle of legal certainty and legitimate interest is really important. There has to be certainty again for investment protection. There has to be a rule of law. I would find it important if the European Commission also acts upon member states that do not apply the rule of law yet. It has to be safeguarded. I think that's very important. But also, I think the EU should embrace and sustain the mutual success of billions investments within the EU. But if you ask me, do I have a concrete alternative towards ISDS on the basis of BITs as opposed to a multilateral investment court? I can't directly think of a new system. I'd rather go back to the ISDS on the basis of the BITs as we had it, with some reforms. I think that would have been the best scenario. But I think the importance is also for the European Commission, involve everybody in this discussion, get structured feedback on all proposals, organize roundtables, further consultations. I think every input would be good, and please carefully listen to the investors, because I think that's the greatest good in Europe. We have a lot of investors, we have a lot of very nice countries to invest in. And please protect that, and let's avoid that well, Europe is being taken over by foreign investors, non-European. We should welcome them, but I think we should also stimulate our own investors. So a lot of food for thought for the European Commission, and I'm happy to help.
Thank you, Nienke. That was, I think that was a great message to end on. Thank you very much to the panelists, and apologies to those attendees who posed questions that we didn't have time to get to. They would have been very interesting to discuss, but we would have been here for another hour if we'd done that. Nikos has just posted the link to everybody in the chat box to the EFILA submission to the Commission's consultation paper, and with that, Nikos, I'll hand back over to you for the final words.
Well, thank you so much to all speakers, to all attendees who stayed so long until the very end. To me, I can only say this is the first time in all the years that I've been following this debate, and this is more than 10 years now. It's the first time I heard a philosophical approach to this debate, really. And I think this is what is needed in this polarized discussion that we've seen, one-sided debate, often by misconceptions. I think it would be really important to take this philosophical approach into account and take a more holistic approach. What I can say is that states, when reforming, should be careful, because what we've seen currently at the WTO and the dismantling and the paralysis of the appellate body is a warning sign that things that we have established over many, many decades, painfully, lawyers, government officials, can easily be destroyed, and it cannot be easily repaired or substituted. So I think that is a warning sign that states should be careful and should embark on a reform process in an incremental and an all-inclusive manner. And I think that has been lacking over the past years. Today we had the views of in-house counsels, of investors, and I think that has been really needed. But looking forward, I again invite everybody to register for our annual conference, because then we will look at the states, and we will look at the renewed role that states are playing in arbitration. And I think that will be as equally interesting to discuss what's happening and showing that we are really interested in providing a fact-based and merit-based discussion. And that is what EFILA has been doing. And I think today we showcased with all of you that we can do it again and again. Thank you so much to everybody, and in particular also to Lucas Mistelis, and I hope to see you very soon. Thank you.
Thank you very much. Thanks everybody for attending.
Thanks everyone. Have a nice evening. Bye-bye.
Thank you. It was a pleasure.